Favor?
Aye.
Aye. Opposed? Motion carries. Next, we will consider the hearing officer's reports. I will call the docket. If you wish to address the commission on a particular docket number, please let me know when we call it. We will mark it ready. We will take up the cases in the order that they are called. First is docket number FIC 2019-0473, Samuel Lopez versus Vernon Riddick Jr., Chief, Police Department, Town of West Hartford, et al. Is there anyone here on that matter?
Mr. Lopez,
Yes.
West Hartford.
Thank you.
You wish to be heard on this, right? Mr. Lopez, do you wish to be heard on this?
Hello? Yeah.
We'll mark that ready. Next is docket number FIC 2019-0141, Charles Wright versus Mayor, Town of Hamden, et al. Is there anyone here on that matter?
Charles Wright.
We'll mark that ready, sir. Next is docket number FIC 2019-0161, Rachel De Leon versus Chief, Police Department, City of Bridgeport, et al. You ready? We'll mark that ready. Next is docket number FIC 2019-0245, Sherry Spear versus Director, MIS Department, City of Norwich, et al. Is there anyone here on that matter?
I'm here for the respondents, only if need be.
Is there anyone else here on that matter? I entertain a motion.
Mr. Chairman, this is dismissal. I move adoption of the hearing officer's report.
Second.
Motion's been made and seconded. Is there discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries. Next is docket number FIC 2019-0271, Kristen Festa versus Executive Director, State of Connecticut, Office of Legislative Management, et al. Is there anyone here on that matter?
Yes, Brian Festa, counsel for the complainant and the complainant.
Okay, we'll mark that ready. Next is docket number FIC 2019-0356, Robert Cushman versus Chief, Southbury Police Department, Town of Southbury, et al. Is there anyone here on that matter?
Mr. Chairman, not seeing anyone here, I move adoption of the hearing officer's report.
Second.
Motion's been made and seconded. Is there discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries. Next is docket number FIC 2019-0480, Matthew Olson versus Director of 911 Communications Police Department, City of Stamford, et al.
Respondent would like to address the commission.
We'll mark that ready.
Complainant as well.
Thank you. We'll mark that ready. Next is docket number FIC 2019-0531, Matthew Olson versus Office of Legal Affairs, City of Stamford, et al. Would you like to mark that ready? I'd entertain a motion.
Mr. Chairman, I move adoption of the hearing officer's report.
Second.
Motion's been made and seconded. Is there discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries. Next is docket number FIC 2019-0576, Dick Gadati versus Robert Murphy, Chair, Harbor Management Commission, Town of Old Saybrook, et al.
I'm here for the respondents. I don't believe that the
Would you like to be heard?
Absolutely.
Okay, so we'll mark that ready.
Well, you do, this is a dismissal.
I have no objection.
I'm just gonna ask for clarification.
You don't want to lose, right? I don't want to lose.
Not seeing the complainant here, I'll move adoption of the hearing officer's report.
Second.
Motion's been made and seconded. Is there discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries. Thank you. Last is docket number FIC 2019-0675, Maria Naughton versus Superintendent of Schools, New Canaan Public Schools, et al. Is there anyone here on that matter?
Yeah, Mr. Chairman, this was withdrawn and dismissed. I move adoption of the hearing officer's report.
Second.
Motion's made and seconded. Is there discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries. Oh, excuse me. Last is consideration of the following proposed final decision, PRVR number 1, Town of East Line and East Line Board of Education versus David Godbout.
Here for the petitioners?
Is there anyone else here on that matter?
Here.
All right, would you like that marked ready?
Yes.
Okay, we'll mark that ready. Before Before we consider the cases, I will ask the Executive Director and General Counsel, Colleen Murphy, to please make the usual announcements.
Sure. For everyone in attendance today, please be aware we don't ordinarily record the remarks made here, but we'll be happy to do so if you'd like us to, so let us know. And pursuant to our regulations, oral arguments 10 minutes per side, and I'll keep track of that for the parties.
So, I'm calling docket number FIC 2019-0473. Samuel Lopez versus Vernon Reddick, Jr., Chief Police Department, Town of West Hartford, et al. FOIA.
Good afternoon, Garmin Newsom, representing the town of West Hartford.
Would you like this matter tape recorded?
No, thank you.
Okay. I'll just let you know that Commissioner Shaw is participating by phone. Oh, is Mr. Lopez on the phone?
Yes.
Mr. Lopez, do you want that matter recorded?
No.
Okay. All right, Mr. Lopez, would you like to begin?
Yes. I was asking for a video dash cam, which they told me that they threw it away. I would like documentation on why and when they threw it away.
Anything further?
No.
Sir? Counsel?
I believe this has already been addressed, but for the sake of making sure that Mr. Lopez understands, the outstanding materials, dispatch recordings, and the audio-visual recordings that he requested, under pursuant to the retention schedule, are to be kept for 30 days unless notice of pending action has been filed with the town clerk. He made his request in July of 2019. The underlying incident, I believe, I don't actually have paper for that, but I believe it's from 2016. And as a result, the sworn testimony was we tend, the West Hartford Police Department tends to keep these materials for perhaps a couple of months. And if there is no notice of an appeal, then the records are destroyed consistent with the retention schedule. So as a result, by the time he requested the records 2.5 to 3 years later, those records had already been destroyed.
Thank you. Sir, do you have any response?
I'm just asking, when you throw out something, are you supposed to document that, or?
In some instances, you're required to make a request pursuant to a form that's required to be submitted to the state librarian. You receive permission from the state librarian's office to destroy the records. In this instance, referring to M7170, which relates to dispatch records, and M7640, which relates to recordings, audio, video, it does not require that we make a request of the state librarian for permission to destroy. It simply is a matter where, after 30 days, unless there's been notice filed, they can be destroyed.
Is there any documentation that you keep regarding the destruction?
That I'm aware of or that's in the record, no.
I think that answers your question, sir.
Yes, it does. I have no further questions.
Okay. All right, I entertain a motion.
Mr. Chairman, I move adoption of the report.
Second.
Motion's been made and seconded. Is there discussion?
No, sir.
Hearing none, all in favor?
Aye.
Opposed?
Aye.
Motion carries. Thank you.
Have a great day.
Thank you, sir.
Thank you.
You can hang up now.
Thank you.
You can hang up, Mr. Lopez. Thank you.
Thank you.
So next is docket number FIC 2019-0141, Charles Wright versus Mayor, Town of Hamden, et al. Grab a seat, please. Sir? Would you like this matter tape recorded?
Yes, please.
Is there anyone else here?
I saw something else.
You know, if you're,
I don't believe the town attorney is here.
Today is Wednesday, February 26th, 2020. The Commission, at the request of the complainant, the Commission is reporting consideration of docket number 2019-0141, Charles Wright versus Mayor, Town of Camden, et al.
Would you identify yourself for the record, please?
Yes, I'm Charles Wright. I'm the complainant.
Would you like to begin?
Yes.
Commissioner Shaw is participating by phone, just so you understand.
Thank you.
Thank you.
And Mr. Wright, you prevailed, correct?
That's correct. There are a couple of amendments, I guess, I would like to propose or ask for. In point number 12, just found that police department respondents submitted a copy of the requested record. I believe that was actually the town attorney's copy or the library respondent's copy. We went to sort of into detail about the fact that the police department's copy was given back to a police officer that wasn't present, and the town attorney brought it as the state and was her copy. And the reason I think that's important is because, and the reason I'm making sort of a request for that amendment is I just want to make sure I'm not getting into a situation, sort of a shell game where if you look at the two at the very end, what it says, the library respondents, if they do not maintain a copy,
Paragraph, please.
it's page 7, number 2.
Okay, thank you.
It says that the library respondents do not maintain a copy of the requested record within 15 days of the notice, you shall file an affidavit. So it's, I just want to make sure that I'm not going to get into a situation where, the Freedom of Information Commission now has the video. We're considering that video the police department's copy. And then in number 30, which is also on page 7, it says the commission declines to order the disclosure by the police department of unerased records. So that's the only points that I had when reading this that I thought were.
So you want to amend paragraph 12?
Yes.
Can you repeat how you want to amend that?
Yeah, I just want to replace either the police department with the town attorney or the library respondents.
So you wanted to read immediately following February 5th, 2020, the February 5th, 2020 hearing, the police department, you wanted to say the town attorney?
Yes. Or the library respondents.
Or the library respondents?
What if it just was the respondents?
In this case, the town attorney is representing the police department and the library, so.
Mary, what is your thoughts on that?
I wouldn't recommend that change, Commissioner. At the hearing, I was a little bit frustrated because I believe the town attorney did hand it to me, but she was acting in behalf of the police department respondents. The town attorney couldn't answer whether or not the library even had a copy, so I took a negative inference from that. I believe it was the police department's copy that was handed in for in-camera record. I have no reason to believe it was the public library respondents, nor do I believe it was really a record of the town attorney. I think the police department had it, and I'm taking a negative inference that the public library had it. And to the extent that the town attorney handed it to me, she was doing it in her capacity as counsel, it wasn't her record.
So, if you recall, I made 2 Freedom of Information requests. One was for police body camera footage that I directed toward the police department, and then I later withdrew that request. So, the town attorney, the only question at issue when it was remanded was not the police copy, it was the footage from the library. But even if it's the police's copy, I guess what I'd like to understand is it the position that the copy that that is now in camera, I'm not entitled to that copy, that's the police's copy. It originated from the library.
The findings that I made, Commissioner, was that the police department copy is now erased, and we can't order the police department to release it. If the public library has it, I don't think the erasure statute applies, I don't think any of the other exemptions that were claimed applies to the, public library record, and so I ordered it disclosed.
But I think his point is, if the in-camera record that we possess is the library's copy, then it goes back to the library, and he believes he's entitled to it.
I believe it belongs to the police department.
So, well, go ahead.
So, yeah, I guess we're at the show game that I've here. You know, I did say that I wanted to ask the town attorney some questions, right? That was an issue, and it was also found that I couldn't do that because the town attorney was acting as their capacity to represent. But the town attorney also is the person that processed my freedom of information request, so I really couldn't get to the bottom of whether this was that. But I do know in the meeting that the police testified that their copy was on a USB stick that was given back to a police officer, and that police officer wasn't present. So the town attorney had a copy. The town attorney gave a copy to the police department, right? But the town attorney stipulated in the hearing that she had a copy of the thing. So.
And she represented all the things.
Yes.
She represented the library, and she also represented the police.
Yes, but, I asked straight out, does the library still maintain a copy? And the response was that they didn't know. So, I was a little bit frustrated by that. I just took a negative inference from it, and I'm finding that they do still have it. And so, I'm ordering disclosure of the public library copy at this point.
Just so I understand, what happens to the in-camera record?
Well, depend on what happens to the case. If it gets appealed, it'll go to the court. If it's not appealed, it would eventually go back to the police department.
To the police department or to the lawyer?
Well, the lawyer would sign for it on behalf of the police department.
So it sounds like you asked the question
Yes.
that Mr. Wright wanted to ask the town attorney.
Yes.
And you got an answer, although it wasn't a satisfactory answer.
Correct.
And the answer was again?
I don't know.
Well,
That was the answer. I don't know.
I guess just the problem, well, it seems to me that the footage came from the library, the town attorney got it, the town attorney gave a copy to the police, kept a copy. And regardless of whose copy it is, there's no dispute that the footage came from the library. And the footage should be released. And it just seems to me that if the library gave their copy to their attorney, and then their attorney gave it to the police, and now it's become a copy of the police, right? Which that's the issue I have is it's I can prevail, but I can't get what I wanted, which is the video.
Well, we don't know that. We don't know if the library actually physically has it or not.
Right, but
I'm making that finding.
But it seems to me that I don't want to burden the library, or it just seems to me if you have a copy and it's that I can have a copy, but we're going to say it's somehow when it's no longer the library's property, it's no longer came from the library, no longer originated at the library. It's now the police's.
The original copy, the record was created by the library, and the police came and they took one of those USB sticks, they took a copy of it. But the original record is a library record in the hands of the library, and I ordered it to be disclosed.
By this Friday, the 20th.
I think I gave them a certain
You gave them
number of days.
15 days from the 13th, so
from
that would be.
Yes, from the date of the notice of final decision.
What would you do if the library comes back and says they do not maintain a copy of it?
Well, that wouldn't really surprise me because they gave a copy to their attorney, right? That wouldn't surprise me if that was the case because it's a video system. I assume it's
I'm just asking you, so hypothetically, if the library comes back and says we don't maintain a copy, what is your response to that?
Number of responses, I still want a copy, and I don't believe that the copy that was given in camera was the police department's copy. I believe it was the copy, it's the library's.
Had you received that answer at the hearing, that the library does not maintain a copy, then would you have felt disappointed?
If the town attorney is representing the library, the town attorney has it, I would contend that the library still has it, because their attorney has it. I mean, for practical purposes, their attorney and them are the same entity, right? I'm not fighting, you know, you can't say that, you know, it's me versus them, and they say, well, I don't have it because I handed it to my attorney, then you ask the attorney, and they say, well, I don't have it because I handed it to them, and you've got the shell game going on, right, which is,
Well, Commissioner, I would suggest that we see what happens when the order goes out and see what response Mr. Wright gets.
Just so I understand that the library gave their copy to their attorney?
I don't know that.
You don't know that?
No. The answer that I received was, I don't know if the library has a copy. I think what might have happened is I think the police might have gone and gotten a copy of it. Taken on one of those little
If you knew that the library received a copy, that the library gave the copy to their lawyer, then what?
well, then if they gave a copy, then they could still maintain the original, which is what I found.
Or if the library gave their only original to their lawyer. Would you expect that to be reflected
Then
in the
if that's the
affidavit?
original, then I believe it's still the library copy, but I don't know that.
Well,
I
no.
didn't get a satisfactory answer.
So the copy in our possession would be a library copy.
I don't believe it is.
so
I believe it came from the police department, or we have witnesses from the police department who bought it, so I think it's a police department copy.
So I do recall that it was found that the town attorney, I remember I brought this up the last time, that the town attorney gave a copy to the police. And I'm pretty sure it's in the record that the police didn't get the copy from the library, they didn't go to the library to get it. That's what I recall.
I don't believe that's in the record.
Any further discussion? Okay. I'd entertain a motion.
Mr. Chairman, I'll move it out to the hearing officer's report.
Motion's made and seconded. Is there discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries. Thank you. Thank you. Next is docket number FIC 2019-0161, Rachel Day versus Chief Police Department, City of Bridgeport, et al. Would either of you like to start a tape recording? One second.
Today is Wednesday, February 26, 2020, the regular meeting of the People Commission request of the Pardons of Commission consideration of docket number 2019-0161, versus Chief Police Department, City of Bridgeport.
Parties excuse me, Commissioner Shaw is participating by phone. Will the parties please identify themselves for the record?
Tina Scala for the respondents. Alexa Millinger from Hinkley Island for Rachel DeLeon.
Thank you. Will the respondents please begin?
So, as a whole, the city's position is that the proposed final decision should be reversed in its entirety. If the commission declines to reverse in its entirety, we would like that the findings regarding two pieces of requested records, or two records rather, be reversed individually. So that would be first, record IC 2019-0161-006, which is the cell phone video that was taken.
Could you repeat the number, please?
Sure. 2019-0161-006.
That's the cell phone.
That's correct. And then the second set of records would be records IC 2019-0161-002, 003, 004, and 005. which are the video and audio witness statement records. So with respect to the cell phone video, the specific portion of the final decision is paragraph 24 that delineates the findings, where specifically.
Attorney Scott,
Oh, yes.
it looks like in 25 that says that one is not exempt from disclosure.
Correct, yes. So, oh, sorry, so that would be both, yeah, 24 and 25, that's correct. So we would argue that the finding that this record is not exempt from disclosure be reversed or remanded to the hearing officer or whatever administrative remedy the commission would find appropriate. The main issue with this portion of the final decision is that there were arguments that were made that were not found to have been addressed. Specifically, whether the video, the cell phone video, was voyeuristic material in violation of CGS section 53A-189A. The city's position is that if there was a finding that the cell phone video was voyeuristic material, then it would be exempt from disclosure under the Freedom of Information Act 1210B12, which exempts information obtained by the use of illegal means. So that there was no finding as to whether this video is voyeuristic material. The city contends that it is. But even regardless, it would be nice if a paragraph were inserted with those findings. But even if for some reason the commission declines to order that amendment, there is significant evidence in the record that would support a finding that the cell phone video is exempt from disclosure under 53A-189B, which holds that voyeuristic material, dissemination of that material would be a felony. So the reason for that would be because in paragraph 24, the hearing officer, commissioner, cites Commissioner of Emergency Services and Public Protection, the Freedom of Information Commission case. And that case is a similar situation to this one, where it is materials that a media outlet requested and the court found that the applicable search and seizure records did not apply and that ordered the records released. But the case states that in the Freedom of Information Act, the portion of 1210BA, I believe, that refers to federal and state laws applies to records and laws that address confidentiality of records and the limitation of the public to get those records. So the voyeurism statute in this case would be exactly that kind of record. It would be a record that states that the dissemination of this record is not only highly discouraged, but a felony. So under that portion of the statute and of the case law, it would be clear that this video would be exempt from disclosure under the standard that is mentioned in this case. And the case also cites another specific maxim that I think is important in this matter, where it states that the exemptions contained in various state statutes reflect a legislative intent to balance the public's right to know what its agencies are doing with governmental and private needs for confidentiality. This cell phone video, which in the interest of everybody else who has attended, to keep it family friendly, is an explicit video of 3 individuals engaged in an act that is sexual in nature. The record has overwhelming evidence from the individual who took the video and from one of the individuals who was in the video that one of the subjects did not know she was being filmed and did not consent to being filmed. The fact that this 10-second cell phone video of a very explicit, intimate act in which one individual didn't know that they were being filmed, does not consent to being filmed in that way, the fact that it would be ordered disclosed by the commission, frankly, the public interest is negligible, even if the complainant has investigatory journalism motives, I guess, for lack of a better word, for requesting it. Others can also request it, and it would be in the public realm. It just doesn't make sense for something that, if it's a crime to be disseminated, would be kept under lock and key, so to speak, but the Freedom of Information Commission would order a municipality to release it. Meanwhile, the public interest in keeping it protected is significant. People who are a victim of what they call non-consensual pornography experience significant hardship, socially, financially, psychologically, and the commission ordering a municipality to release something that we contend is against the law to have been produced in the first place, it would contravene the point of the voyeurism statute in the first place. So, just in the interest of a fair, common sense interpretation of what the Freedom of Information Act is trying to do and what the Voyeurism Act is trying to do, we would argue that this video should not be ordered disclosed to the complainant or to anybody else. And then, I'm not sure how much more time I have, but with respect to the audio and video witness statements, we would also argue that these audio and video depictions of witness interviews with the police in this matter would be exempt from disclosure under section 1210B3C, which exempts signed statements of witnesses. The reality today is that municipalities very rarely have signed statements of witnesses anymore. Often it does take the form of a videotape or an audio tape of a witness, and that's for a number of reasons. It's either because it's more accurate or more cost effective or time effective. It allows the law enforcement agency to be more engaged with the witness statement gathering process, the interview process. The commission ordering disclosure of a witness interview is contradictory with the fact that the Freedom of Information Act and Commission have demonstrated an interest in keeping witness statements private under the Act. The mode that this witness statement would be taken, we frankly feel that it's irrelevant. In the interest of keeping witnesses safe and their statements safe and protected, we would argue that the fact that a witness statement or interview is in an audio or video form would not matter. It would still be applicable as exempt under the Freedom of Information Act. So again, it would be the same kind of idea of a common sense interpretation of the statute rather than a literal statutory language interpretation. Just in one more note, the proposed final decision cites the Sendensky decision, which holds that 911 calls are not exempt from disclosure under 1210B3C. 911 calls are distinguishable in this case from video and audio taped witness statements and interviews, because this is a literal depiction of what the witness looks like. Even if you blur out their face, the topic of conversation, the statement itself, what information they know, could lead people to deduce these witnesses' identities. And the witnesses themselves, if they know that a video of them speaking to the police would be subject to public disclosure, would have a chilling effect. Witnesses would not feel comfortable cooperating with the police and providing statements or even being interviewed. So again, in the interest of common sense and practical application, we would argue that the witness statements, audio and visual, are also exempt from disclosure under 3C, and would ask that the commission amend particularly paragraph 20, which addresses the finding that they are not exempt from disclosure under B3C, to amend that they are, or reverse it. Thank you.
Thank you. Again, I'm Alexa Millinger on behalf of the claimant Rachel De Leon. Rachel is a reporter for the Center for Investigative Journalism. She requested the records. The city already spoke about it. I don't need to go over that. 6 different records, and the decision obviously found that they were all not exempt from disclosure, and I support the proposed decision, obviously, but wanted to address a couple of the city's arguments. First, as to the cell phone video, which was 0161006. The city's arguments generally, the problem is that they're public policy arguments, what they call common sense arguments, but are not unfortunately rooted in the language of the Freedom of Information statute. The exemption that the city tries to bring the cell phone video under is 1210B12, which is for information that is obtained by illegal means. And the city's argument is that the cell phone video, because it was an act of voyeurism, was therefore obtained by illegal means. But in making that argument, the city is missing the point of that exemption, which is that it refers to records that are obtained by the agency by illegal means, not records that were created by illegal means. And of course, I'm sure you can think of many examples of records that were created by illegal means that were then seized by the police and then kept in the police department. And there's no argument there that those are exempt from disclosure because they were created illegally. So here, a finding as to whether or not the cell phone video is voyeuristic is not necessary to the analysis here because there's no contention that the agency engaged in any act of voyeurism, which is the only relevant inquiry here. And I believe the record finds that the agency obtained the cell phone video lawfully as part of an investigation into allegations of sexual harassment. There's no contention that the agency did anything illegal here in obtaining the record, which again is the relevant inquiry under 1210B12. And even as to, there's also not sufficient information from the record here to determine that the material is voyeuristic, even if that conclusion were required, which again we contend is not. At the initial hearing back in July of 2019, the city didn't put on any evidence whatsoever as to whether the material was voyeuristic, how the video was created, anything whatsoever. And then subsequently filed two subsequent motions to reopen evidence, which were granted, and they were allowed to put in two different sets of documents, which were excerpts from transcripts of different legal proceedings. And that's the evidence that the city relies upon to argue that this video was an act of voyeurism. But again, just relying on a couple of statements from deposition testimony was not a sufficient basis for the commission to find that there was an act of criminal voyeurism here. No one was charged with voyeurism in connection with making the cell phone video. There's no evidence that anyone was and no one was. And just bringing in these couple of pages of deposition testimony, no one's able to determine the credibility of the witnesses, assess the credibility, cross-examine them. So from the evidence we have in the record, we can't make the determination as to whether this cell phone video was voyeuristic. And again, whether or not it was voyeuristic is not relevant to the determination of whether it falls under the exemption under 1210B12. And then I'll briefly address the city's other arguments, although I, again, am in agreement with the proposed decision as to the witness statements, the video and audio witness statements. The city hasn't presented any law or any other compelling reason to deviate from the clear law in the Citizenship versus Freedom of Information Commission case that held that that exemption refers to a written witness statement, and this is not, and it's as simple as that. So again, the exemptions are to be construed narrowly, and the narrow construction of that exemption is it refers to just pieces of paper signed witness statements, not to audio or video recordings. And to the city's argument, a 911 tape also includes other identifying features such as the person's voice or the story that the person's telling in the 911 recording, but the Supreme Court didn't find those as compelling to warrant it falling within the exemption. And I believe that's all. So for all of those reasons, support the proposed decision.
I'm going to take a brief recess to review some of the material, but are there any questions before we do that? Okay, let's take a brief 10-minute recess.
I'm gonna end up having